Legal mode, Colorado. Consequences if the defendant won the rehearing and the PPO was revoked after video body cam evidence. If the PPO against Thayer was revoked after a rehearing, that is a major legal inflection point. It materially alters every related issue: criminal, civil, and future protective filings. Here is the precise real-world impact. Number 1. Legal meaning of PPO revocation after rehearing. A PPO revocation after rehearing means the court found one or more of the following. The original PPO lacked sufficient factual basis. The petitioner's fear was not reasonable or credible. The petitioner misrepresented or omitted material facts. The petitioner's post-order conduct contradicted the need for protection. New evidence overcame the original findings. Continued enforcement would be unjust or improper. This is not a technical dismissal. It is a substantive credibility ruling. Number 2. Effect on Fredrickson's PPO TRO filings. A. PPO is legally null going forward. Once revoked, the PPO no longer exists. It cannot be enforced. It cannot be relied on retroactively to justify conduct. Any claims based on it lose force. B. TROs filed by Fredrickson are severely undermined. A court that just revoked a PPO will be highly skeptical of any TRO by the same petitioner involving the same respondent. Judges will view same parties, same allegations, same time period as relitigation unless genuinely new, independent facts exist. In practice, TROs are often denied outright or dismissed at the return hearing or converted into no harassment admonitions only. 3. Effect on the harassment citation against Fredrickson. A. Revocation strongly supports the prosecution case. While the criminal court is independent, PPO revocation confirms Fredrickson was not acting as a protected party, confirms his pursuit was not justified, confirms lack of reasonable fear, supports intent to harass rather than self-defense. Prosecutors routinely introduce the revocation order, the court's findings, the rehearing transcript if available. This strengthens, not weakens, the harassment case. B. Defense arguments collapse. After revocation, Fredrickson cannot credibly argue, I was protected. I had to defend myself. The order required me to act. I was enforcing court authority. Those arguments are effectively foreclosed. Or 4. Effect on claims that Thayer avoided service or provoked. Once the PPO is revoked, claims that Thayer was avoiding service lose context. Claims of provocation are viewed through a retaliation lens. Prior restraint asymmetry no longer exists. Courts reassess earlier conduct with fresh neutrality. If the revocation was based on video body cam, objective evidence now governs the narrative. Subjective claims lose weight. 5. Collateral estoppel persuasive effect. While not automatic issue preclusion, PPO revocation after rehearing has strong persuasive effect in criminal harassment proceedings, TRO return hearings, any future PPO attempts, motions for sanctions or abuse of process, credibility determinations. Judges do not ignore a sister court's findings on the same incident. Number 6. Exposure for Fredrickson after revocation. Once the PPO is revoked, Fredrickson faces increased legal risk. A. Criminal. Harassment conviction or plea becomes more likely. Self-defense narratives are weakened. B. Civil/procedural. Abuse of process arguments gain traction. Vexatious litigant warnings become more plausible. Sanctions become possible if filings continue. C. Future protection orders. Any future request by Fredrickson involving Thayer will be scrutinized for retaliation, bad faith, relitigation, harassment through filings. Courts may require higher evidentiary thresholds, attorney review, explicit warnings on misuse. 7. Effect on Thayer, defendant who won rehearing. Winning the rehearing and revoking the PPO restores full freedom of movement, eliminates violation risk, confirms lawful avoidance behavior, bolsters credibility in all related proceedings, provides a clean record for rebutting future claims. This is the strongest procedural posture Thayer could have. Number 8. Bottom line legal consequences. If the PPO was revoked after rehearing, Fredrickson's fear claims are judicially rejected. PPO-based justifications for pursuit are eliminated. TRO filings by Fredrickson are severely weakened. Harassment prosecution against Fredrickson is strengthened. Abusive process arguments gain force. Future filings by Fredrickson face heightened scrutiny. TAC, practical reality. In Colorado courts, a revoked PPO after rehearing changes the entire narrative. From that point forward, Fredrickson is no longer viewed as a protected party, but as a litigant whose credibility has already been judicially questioned. If you want, I can next explain how to use the revocation order in the harassment case, draft a response to any remaining TRO, help prepare a record to deter future filings, outline possible sanctions or vexatious litigant paths, help analyze what language in the revocation order matters most. Just tell me the next step,